problem when landlords and tenants' relationships break down. The tenant won't let the landlord into the property at all, even for things that actually are in the tenant's interest. So sometimes tenants won't allow access for repairs, even though they're then complaining about those same repairs. They won't allow access for landlords to carry out their mandatory gas safety certificates, or they won't allow access, and this is the most common one actually in practice, for viewings when the tenancy is coming towards an end, it's clearly not going to be renewed, and the relationship has collapsed. There are a number of different positions. The sort of starting point in all these cases is that landlords aren't entitled to force access. Just because there is a clause in the tenancy agreement that entitles you to access to the property, that doesn't mean you can go and boot the door down and enforce and self-help the access. What it actually means, of course, is in theory you can claim damages for breach of contract. You are also entitled potentially to go to court and seek an injunction for access to compel access to the property. Now in practice, that's only normally done by social landlords who have very long-term tenancies where they don't have much right to secure possession, because it's a horribly expensive and impracticable solution. In most cases, you're much better off to simply take it on the chin, work on getting the tenant removed from the property altogether, and start again. And although that will seem expensive if the rent's not being paid or something else happening, it's a lot cheaper than going to the High Court for an injunction, which will cost thousands and thousands of pounds. And even if the tenant doesn't obey it, you're still going to have to go back and push it harder to actually get it obeyed. In respect to the particular examples, if there's a disrepair problem, then it's unlikely to get a huge amount worse. If it's really, really bad, or if it's causing leaks into other flats, then an injunction would probably be your only solution, and you probably get one relatively quickly in those cases. It may be possible, if the property is really bad, to ask the local authority for assistance and effectively self-report under the HHSRS to encourage the local authority to serve you an improvement notice, which would allow you to use the magistrate's court to force access to the property, or even a prohibition order, which of course would prohibit the tenant from living there at all, and therefore would effectively terminate their tenancy. That can be a sort of effective tactic in some cases. Your mileage will depend on the local authority. Some local authorities are pretty reasonable about this and quite cooperative. Some local authorities are very difficult about it because they're aware that if they serve a prohibition order, they then attract a homelessness duty in respect of the individual who's being pushed out. So there is a sort of tension there. In respect of gas safety certificates, the Health and Safety Executive has clear guidance that they won't prosecute for failure to have a gas safety certificate, provided that you have made at least 3 clear efforts to obtain access. So you want to show that you've made at least 3 attempts to obtain access by writing letters, booking appointments and having the contractor refused, and phone calls and things. And you should keep up the pressure. So you've got a clear chain of evidence in case someone was to turn up later and say you don't have a gas safety and something terrible's happened here. In respect of the other problem with gas certificates and the kind of area is Section 21 notices, because of course you can't actually serve a Section 21 notice if you don't have a valid gas safety certificate. This is actually a bit of a flaw in the legislation, in that in theory a tenant can refuse access for a gas safety certificate and at the same time therefore stop you serving a Section 21, so you're trapped. In those cases you would either have to look at an injunction for access to do your gas safety, or you would have to consider whether you had some alternative ground for possession under Section 8, and you probably need to go and talk to a solicitor realistically. Finally, repairs. Well, if a tenant won't allow access for repairs, actually this is not as bad as it might first appear, because if you aren't allowed access to do repairs, you're not liable for the repairs. If it comes to viewings, then you're just not going to get the viewings. It's hard to claim damages for failure to allow access for viewings unless you can prove, and this is really hard, that if they had allowed access for viewings, you would have rented the property more quickly. And that is possible, but quite hard to produce.